my best to do a 15, let's say a minute elevator speech on that process of recording your land purchase. So as a real estate broker, how they gain jurisdiction over a piece of property is the DRE puts residential purchase agreements and residential rental agreements out there. And so these words that are on these documents are trademarked and belong to the United States. And so when you're using a real estate broker, you're having an agent in place and you're using these forms, these are all things that we kind of fail for lack of knowledge. Like we don't realize that we can actually do a transaction outside of using those forms. It's called a private land purchase agreement. And you can create your own purchase style agreement. So I want to just focus on your question and help you to understand the difference of two deeds. You have deed A, where 99.9% of all the people are recordation on a deed is in the name of a registered organization, like your all caps name, a registered organization, Uniform Commercial Code 9, it's the birth certificate, it is the US citizen, and they own it. So the live born record was your family's, it was given over to the state at the birth, the state took it, put on a 32-pound watermark banknote paper, put it into the public to make a claim, and nobody came in and made a claim against the BC. The BC now is owned by the state. One of the definitions of birth is abandonment. So they are taking the claim equivalent, the title of the child, and they're putting it into the public on an abandonment certificate. Nobody's coming and making a claim. State owns the product. Secondly, the mother and the father who got a marriage license, there's Supreme Court rulings that when you enter into a marriage relationship with the state owns the product of the union, the children. People don't realize that these things are accurate, lawful, legal, and why CPS can come and take your kid at any time. Plus, the father isn't signing on the live born record. Plus, the mom is saying that she is agreeing to being a guardian, which is what a parent, the definition of a parent is. It's a judicially decreed guardian. So the mom is agreeing to these terms because she's agreeing that she is this person and putting her signature on that live born record. So we fail for a lack of knowledge. I know I went a little overboard, but this stuff is really important to get. And so now that registered organization name is on a deed, the state owns it, not you. Secondly, your recordation is in the name of a joint tenant instead of the proper fee simple or there's other options. You're using a legal description that's above ground. Who owns the terms within the legal description? The country or the corporation or the Vatican, whoever. I honestly haven't chased that trail down. I don't really care. I know a legal description is above ground. It's territory. It's not a piece of land. And so you've got a recordation in a name that they own and control, or you put it in an LLC, they own and control LLCs. People don't understand that when you create an LLC or a corp or an S corp or C corp, any of these registered organizations, actually, even if there's stock issued in them, the state owns it. The state of Delaware, the state of Nevada, they own those entities. The certificate of stock is nothing but a piece of paper and just to try to find who the liability is in that corporation in the event the state wants to come after for tax. I need you to think about it that way. And so when you're doing a purchase of a land agreement, the thing that sucks is, and it doesn't really suck because there's workarounds, but is you can't get title recorded in the name of a private foundation. And so you got to make sure you're not putting Federal Reserve notes, because that's how grand deeds are written, for valuable consideration in United States dollars. They use the dollar, symbol that belongs to the United States, and a given amount for valuable consideration of X. Grantor hereby assigns to grantee the property hereby described in Exhibit A, boom, 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 boom. And what you're doing is you're giving these 5 elements of within the deed that you don't own it. You're using a Federal Reserve note. You're using a legal description, and you're even vesting in a tenant format. We fail for lack of knowledge. Look, I got hoodwinked. Just like everybody else out there, we all get hoodwinked into these structures and systems by these bad guys. And I'm calling them what they are, because they want people to think that that's the way it should be. And as you know, a broker in the state of California, I'm telling you, you can record in any type of format that you wish. And you just have to show a proper way of a deed. And so when you're in a living in the private program, we will actually give you a copy of a grant deed that you can utilize as a template for your property. And we kind of give you form and function of how to do it. But here's the net of it. It's 5 elements. And the deeds of everything prior to like 1950 were pretty much like this, 100%. And this is why we fail, and it's okay. This is why we're learning today, and we're coming through to the other side of this. But we are successfully recording these all over the country, for valuable consideration, by gold, by hand, or with gold, by hand, of an undisclosed amount, grantor, and it could be any name, whoever it is you're trying to purchase from, hereby conveys, sells, whatever, and you're not using the purchaser is not using a registered organization. Purchaser is not using Federal Reserve notes. Purchaser is not using a legal description. Purchaser is not vesting in a joint tenant. Purchaser is a private unregistered entity. Purchaser is using gold, taking the element of Federal Reserve notes out of the equation, whereby the United States is no longer a party to the transaction. So when you're walking into a recorder's office, you have literally right there, you have 2 elements, just like literally when you're walking into the federal court in Santa Ana, California, there is 2 federal courts in there. There's one for the de jure and there's one for the court. I'm not exaggerating. I've seen this with my own eyes from paperwork that was given out by that court on the de jure side and that court on the de facto side, 2 different names, same address. It's the same principle at the registrar's office. So what is the term registrar? It's basically a bank. What is the term of the recorder? Is also the registrar. So the recorder has that same dual principle, just like a judge. When you walk in that court, if you're a U.S. citizen, you don't have access to the Bill of Rights, and they know that. How do they know that? Because of a driver's license, because of you are in their system. It's pretty self-explanatory. And this is why they always have to get subject matter jurisdiction before any indictment or any warrant. They have to prove that the United States corporation has jurisdiction over that living man or that living woman. Now, aside from that, going back to the deed, in that deed, if you record those 5 elements, you bring it to the recorders, you're not bringing it to the registrar's office. We are handing over our transactions that are ours and making them theirs by the way that we are vesting, by the style in which we're recording and registering that property. Did you know that if you don't accept the deed on the spot, there's only the seller? I mean, the way that they do these things is pretty nefarious, and you can go to store.HISAdvocates.org and you can get a copy of the deed acceptance package just for your own perusal. It's cheap. I think it's still $1 or $20 or something like that. I don't remember. But it's helpful to get your mind wrapped around what a deed acceptance is. That's the other element people are failing. You're not accepting the transaction, and it gets recorded into the public. And this is why they are able to do, from a taxation element, what they do. Nobody bought it. Okay. And it was completely given over to the state at the time that deed was written. And the only person's transaction they need is the seller's. The only signature they need is the seller's. What does the word signature mean? One who can attest to the validity of the instrument. Now, look, there's a lot of people that may say this is poo-poo, that may say this is unrealistic, that may say this doesn't work. I'm telling you it does. And I don't need a broker's license to know the difference of me going in and actually doing and effecting a good deed versus a deed that is above the land, using an entity that they own, that they control, using Federal Reserve notes that they are a party to, using a legal description that is not land. You know what I'm saying? And so hence, therefore, because of every element of trickery by them, you're not even accepting the deed. You're not doing anything in accordance to what you should be doing. And you're using the wrong everything. You really want to be a tenant? Do you? Do you really want to own air? Is that really what you want? You really want to use a fiat worth nothing Federal Reserve note that they are now a permanent party to? Really? That's what 99% of the people are doing. And we think we're purchasing a home, and we're not. You're purchasing an area above land, and you're a tenant at best, and you're registering and giving that deed over to them because you're not accepting a properly formatted deed. Now, empty pockets, that was probably a little too long, but that's a reality check for a lot of people that are out there. And there's people out there that are talking about these land patents. And hey, look, first and foremost, I like Ron Gibson. I like his work that he does. I like that whole element of trying to figure out how to accept the land patent. But people, they're thinking through things wrong. And I'm not saying his work by color of law isn't having form or effect. What I'm saying is how do you accept a land patent when you're not a party to it? Well, the only way is to pull the property out of the county recorder, because that land patent was done to a family or a trust or a name 100 years ago. There is no land patents being written out today. There hasn't been a land patent written out in a long, long time. So if you're not a direct assign from that original land patent, how are you accepting it? You're not, especially when you're doing it in the recorder's office. You're using a substandard, subpar recordation to affect the fact that you're accepting this land patent of a smaller portion or smaller area than the actual land patent is. So maybe having form and effect, I haven't seen any. Maybe having a real change for yourself, I haven't seen it. Why not buy the property, buy the land out of the jurisdiction of the United States like I did, like I told you, and then withdraw the deed from the county recorder? Now, one of the questions, this is an amazing story I'm about to say. There is no lawful, listen to me, there is no lawful requirement to record a deed in the county recorder. None. I got that question wrong on the broker's exam way back in the day. I'm like, and I just started thinking, what are the ramifications if you're not recording something in the county recorder's office? What does that sound like? What does that end up like? I'm telling you, that's a beautiful thing. And if you are able to withdraw, and it's going to be a fight, they're not letting go of this stuff easy. If you're able to withdraw a piece of property from the county recorder's office, and it's not, the grant deed is not in there, and you're not recording the new grant deed of the sale, who are they going to bill? You're not accepting the deposit of the valuation equivalent, the benefits of the deposit of the deed in the county recorder. You're not accepting the fire and the trash services from the city. You're not accepting the benefits from the city, and not doing a recordation of that deed in the county. What are the ramifications? I want you to think about that, because the success on the other side of that, of removing the property from the county recorder, what are you sitting on now? You're sitting on some patent that the city now doesn't control. The city now has no say, because you're not partaking in that APN, which is the parcel number for that particular property in that particular space in that particular county. Point being, you really want to have form and effect, get out of the county. And you can't get out of the county until you have a property free and clear of any encumbrances, but you can once you do. And that's a huge thing that we are going to bring forward. We already are bringing forward, but we're going to bring forward with case law to support it, to help people down the road. Our whole next level of everything that we're doing is enforcement, guys. This is going to be a huge change for you guys, his advocates. His advocates, people that go through the living in the private right now, they don't get harassed, they don't get mistreated, they don't get handled wrong. Everything is kosher and cool with all the people going through the living in the private program. We're just gearing up for what they're gearing up for, and we're going to make it so that people are protected all the way through. And we're going to be introducing things to you guys that you never knew really existed. We just shot off our first video on YouTube. You can go and check it out. It was just posted a few days ago. Go under, just click on videos and go to 325. These guys one's active duty law enforcement. He has had an amazing amount of success in getting the departments to move and do anything that he needs. I just posted the video in the chat area. I'm also going to go back and post it into the YouTube chat area. Those guys and I are creating a system that's going to go worldwide on every TV, and people will have the ability to partake in learn how to deal with foreclosure. That guy has been in his house without a payment made since 2008. I'm telling you, they know what they are doing. So on that note, if you have any questions and you're on the Zoom meeting over here, we got about 40 people, 38 people over here, and 16 over on YouTube. Welcome, YouTube. Soon we're going to be doing these live on HISAdvocates TV. The reason why I still like the YouTube is we got the interaction with the comments and the Q&A, and we were able to answer questions on